I think it was a week or a week and a half ago, I had given the court and afterwards provided the state also with a copy of information that we're relying on. And that deals with some other sentences within Duval County for similarly charged crime. Based on the information that we've been provided, there's been only 2. And I know I had said this when we were here last time, but I know you had a full docket that day. So based on what we have been provided, the 2 cases were both minimum sentences, the lowest permissible sentence. One of them was, I believe, a 62-day credit time served sentence. And that particular person was scoring, I believe, somewhere in the 30s, 26.4, my mistake. And received a 62-day sentence, and I believe that was a time served sentence. If I'm incorrect about that, I'm basing it on what I've been told, but I'm pretty sure with the number 62, that's not a typical sentence. It's just what's time served, where typical sentences are 30, 69, etc. The other case that I have that I had mentioned the other day, I'm also basing on, and I have a copy of that score sheet in front of me, a 19.575 score sheet, a 19.57 month sentence. So it seems historically within this court, assuming the information I've received is accurate, that we have a, although very minimal history with this particular crime in this county, a minimum sentence as a customary. If this were not the case, and the only one I'm not positive of is the 62-day, that person was sentenced to the 62 days and scored more than double what Mr. Williams scores on his score sheet. And I would suggest anything more than a 62-day sentence in this case would seemingly be inconsistent with what the this courthouse has been doing. Okay, those are the only cases I'm aware of within this county and within this circuit. What I provided to the court, I went a step further and I asked for information statewide because there was so few cases here, to give the court, the state, Mr. Williams, a fair representation with these types of cases statewide. And based on the information that we've been provided and that we've provided to the court and the statewide search of anybody relatively close to Mr. Williams on that score sheet, you have 4 sentences, a half of a year, 2 months, and 3 months, and one of them with 2 years. It is my understanding that the 2-year sentence was a concurrent sentence with something else. So if that's the case, then statewide, the maximum sentence for this particular charge that has been handed down for anybody between 10.4 and 11.4 on a score sheet is 6 months. Going a step further, as you have had an opportunity to review, statewide, if you go higher up to, I believe it was about 25 points, so more than double of what Mr. Williams, it's all over the place. But by and large, they're relatively minimal sentences, and even with somebody close to the 24 range getting a time served sentence. I don't know how much time that was, but you have people that are scoring higher than Mr. Williams that got no jail for 1 month or 5 months, but admittedly, you do have a few thrown in there that are higher, that are in the 1-year range. But in the spirit of fairness and candor, I wanted to go beyond just this county because there was so little available in this county. Obviously, I like this county's history of bottom of the guideline, but I thought that the court would be better prepared for a sentence having more of a statewide perspective. From a factual standpoint, in this case, the ankle monitor was removed, and I believe it was removed at 17:48. There was an alert of a violation, and at 18:40, after being asked to return to his residence, Mr. Williams returned to his residence. We're dealing with a approximately 52-minute time frame where Mr. Williams was unaccounted for. I looked at the police report for the gentleman who received a 62-day sentence in this courthouse here, and that ankle monitor was removed. And while he did make an utterance that it was too tight for him, he was found in a shed/laundry room, I believe, within the property. I don't know whether or not that was an effort to hide, or whether or not he was in there to do his laundry. So I can't make that assumption, but I do know that that's the room that he was found in. And as the report reads, though I don't know, it seems like that is a separate part, or maybe a separate structure. But I've just read the report and it's not clear on that. So based on the history from a statewide perspective, at least with reference to the information that I have been provided, that a fair sentence would be a time served sentence. And in this case, time served is somewhere in the neighborhood of 50 some odd days. I think it's about 55 days that Mr. Williams has time served on this particular case. I think that would be consistent with what's happened in this courthouse with somebody twice as much on a criminal punishment code score sheet. So that's what we're asking this court to do here today, is be consistent with that other sentence.
All right.
Thank you.
And what do you show for time served? 52. Okay.
And we'll agree to that 52 number.
Right. Let me hear from the state.
Your Honor, first and foremost, this report is not relevant. There is no plug and chug calculation to determine a sentence. A proper and just sentence is one that is determined based on a defendant, their past, their criminal history, and the facts and circumstances surrounding their charge. But let's talk about this report aside from its irrelevancy. So on pages 2 and 3, you have what has been titled data caveats. And I'll just read a couple lines from here. It states on page 2, unfortunately, it is not uncommon to find errors, inconsistent, incongruent, and or missing and omitted data. On page 3, it says it is impossible to determine exactly how many dispositions from the statute at hand may not be included in the DOC database and therefore ESAS. The data provided for this circuit shows two cases from 1998 to 2002. Common sense tells us that this is an incomplete picture of this charge, and I can state for a fact I right now have 2 cases. So it's hard to believe that this is a historical picture of what people have been sentenced to based on this charge from 1998 to 2002. But let's also talk about the 2 charges, or the 2 cases that are referenced in this report from Duval County. The first one, 21 CF 691. It's common sense to think that a person that's on an ankle monitor has some additional case or some sort of background that has landed them on an ankle monitor. So I looked into this case and this defendant. He was also charged in Clay County with an aggravated battery. It was a domestic case with an uncooperative victim. And he ended up pleading to a total of 7 months in the Florida State Prison. So while on the tampering case, he received a time served, in total, he received 7 months with an uncooperative victim. The second case, 21 CF 9533, that individual was actually on conditional release from the Florida State Prison after he had been sentenced to 7 years on a charge. He removed the ankle monitor and he was sentenced to additional prison time after his 7-year sentence. These 2 cases alone demonstrate why this report does not provide guidance for the court as to what is a proper and just sentence in this case. So let's talk about this defendant and what the court should consider in sentencing this defendant. His criminal history includes a 2017 carrying concealed firearm where he received a withhold and 16 months of probation. He was sentenced to that sentence on March 30th of 2017. By November 16th of 2017, he had picked up a first-degree felony, a tampering with a witness, where he was adjudicated guilty, which is what made him a convicted felon, and sentenced to 8 months in the Duval County Jail. And what brings us here today? Well, as the court knows, this defendant had been arrested for a possession of a firearm by a convicted felon. A jury of his peers found him not guilty, and of course, the state respects that jury's verdict. But that is what landed him on an ankle monitor. He was on that ankle monitor beginning July 28th of 2021. By August 29th, 2021, this defendant removed that ankle monitor. And there was some talk about the prior 2 cases. Well, in those prior 2 cases, I think it's important to note that the individuals admitted to removing the ankle monitor. This defendant, once he got caught, said, "Oh, I looked down and it was gone." He doesn't even admit that he took the ankle monitor up. And I think there was another story about how he was breaking up a fight and the ankle monitor somehow fell off. And in the police report, you'll see that the officer who responded said that that is an impossibility, that it takes a great deal of force to remove these ankle monitors. There's also some talk about this 52-minute window. Well, that 52-minute window is because someone called him and said, "Hey, they're here at your residence looking for you." But for them knowing that this ankle monitor was off of him and coming to the residence to look for him, we have no idea how long he would have kept that ankle monitor off. And we have no idea where he was. An arrest warrant was subsequently issued, and he was arrested for removing his ankle monitor. And it is notable that when he was arrested, there was a firearm in that car. Your Honor, this defendant has a history of firearms, being around them, being in possession of them. The court has heard evidence of his past history. And also, it's again notable that his prior felony that makes him a felon, unable to possess firearms, is a tampering with a witness. And here we are with a tampering with an ankle monitor. While the defense wants the court to align its sentence with what they're calling a historic sentence in this county of basically time served, the state of Florida does not believe that that is a proper and just sentence based on this defendant and his criminal history, what his priors are. The state is asking that he be sentenced to 12 months in the Duval County Jail with credit for time served, and following that 12 months that he be placed on supervision. This defendant has been placed on supervision previously and not followed through. He was on probation for his carrying concealed firearm, and when he was placed on an ankle monitor, in this case, he cut it off. So the state would be asking for a period of supervision following his incarceration.
All right, do you have a score sheet, Mr. Williams?
Your Honor, I did provide it at the last court date. I'm not sure if Madam Clerk still has it.
I have it. Check. I have it. Were there any exceptions or objections to the score sheet from the defense?
May I take a quick look, Your Honor, at what you've got there?
Sure.
No objections to the score sheet. Right.
Ms. Anderson, as to Mr. Williams's prior record, are there any offenses in his prior record that are not scoreable and therefore do not appear on the score sheet?
There are no offenses that are not scoreable.
going to take a brief recess and I'll pronounce it.
Yes, Your Honor.
Your Honor, you had told me that I'd get the last word.
Oh, I'm sorry. Did you go
I
ahead?
didn't know if you wanted to take your
apologize.
recess and
I
then.
apologize. No, go ahead. Let me hear from the defense.
Thank you. A couple of things.
Sure.
Number one, as it relates to the score sheet, the two priors that were mentioned are now 6 years old. First of all, and they're third-degree felonies. I know there's some misdemeanors in there. There's no dates on that score sheet, but just from a perspective, from a time perspective, they're 6 years old. As it relates to the other cases that are mentioned in this and the lack of value in this particular report, we verified the two Duval County cases. We verified both of them. And the interesting thing about the state's argument is they had mentioned these were because that they had other charges that they also were sentenced to. Where our case is unique, there was no other charge that he was sentenced to. We went to trial. As the state had mentioned, the jury came back with a not guilty verdict. That's the charge that he was on his ankle monitor for. And while there was some issue made with this is what made him come back, he got a phone call saying they were looking for him. That's the point we're making. He did come back. If he was trying to hide, trying to run, he wouldn't have come back. But he came back. Not only did he come back, but he came back quickly. I would say immediately upon getting that call, hey, they're looking for you. He came back. That's the 52 minutes that we're talking about. From the time of the alert went off until the time that he was face to face with somebody was a grand total of 52 minutes. So we do have unique circumstances here that justify a time served sentence. If he had not done a day on this case, we would be asking for a time served sentence. He's done 55 days on this case, which is more than a day per minute that he was out of sight. So based on the information, not only in the report, but the information that we have verified through this clerk of court here, we're asking, and we believe that a time served sentence in this case is consistent with the history of this courthouse and is appropriate, giving his 10.4 points on a score sheet that most of those points come from 6 years ago. So we'd ask the court for a 52-day sentence with credit for 52 days time served.
All right.
Can I add one more thing?
Of course.
Thank you. The only other thing I wanted to mention is that Mr. Williams is planning on moving to Atlanta full time upon the conclusion of this case. This is not something where this community is going to have to see him, hear from him. I understand that that doesn't mean much as it relates to whatever his future conduct may be. He can do it here, he can do it there. But we now have, again, a 6-year gap in between convictions. And I think that that justifies that with the minimum amount on the criminal punishment code score sheet, a 52-day sentence.
All right. I'll take a 15-minute recess. We're up for a break anyway. And I'll just, so council knows what I'm considering in the sentencing decision for Mr. Williams. Obviously, any sentencing is highly individualized. This is a level 1 offense. It's the lowest grade felony offense. At the same time, this would be Mr. Williams's 3rd felony. While I appreciate there's a gap in time, that's a substantial prior record. So that's what I'm wrestling with. We'll be back at 11 a.m.
Thank you.